AnibalShow.com.
In about 14 states, the untold victory was that state anti-immigrant legislation was defeated. Those are the states that are colored blue on the map. And then you saw 5 states, in addition to Arizona, passing state anti-immigrant laws, and those are the states labeled in green: Utah, Arizona, Alabama, Georgia, and South Carolina, as well as Indiana, which had a slightly scaled back version. Now, the good news is that those states are colored green on this map because in every single state that passed one of these laws, key provisions of the law were enjoined by district courts in litigation that either we brought as part of a civil rights coalition or in response to the Justice Department's lawsuits. The current status, as you all know, is that all eyes are on the Supreme Court, which is considering SB 1070 itself. There are 4 provisions at issue there. And the status in the other states is that we have our preliminary injunction hearing in Utah next Friday, where a TRO has been in place since the day that the law was to go into effect. In the other states, injunctions are in place against key provisions, with the exception of Alabama, where, although key provisions were enjoined, the basic show me your papers law, the provision that requires police officers to check status during traffic stops and other encounters, was not enjoined by either the district court or the 11th Circuit. CLU and the National Immigration Law Center were partners on all these cases, and the Southern Poverty Law Center, MALDEF, and many other civil rights organizations joined in the coalition effort in all of these states. In all the states except for Georgia and Indiana, the Justice Department came in later to file suit after being publicly called upon to do so by the Civil Rights Coalition and other civil rights organizations, as well as members of Congress. So the missing pieces, as far as the Justice Department is concerned, are Georgia and Indiana. Now, I bet you're going to ask me why that is. You should ask Tony West when he talks to us later on today. But the observation I would make is that the Justice Department has, in its preemption arguments, relied heavily on the fact that the state laws, by and large, impose a mandatory requirement on state and local officers to check immigration status out on the streets. Georgia's law does not require that as a mandatory matter. The Georgia law gives officers in this state discretion to check immigration status or not. And so that could be reading between the lines of their arguments in the states where they have filed suit, a distinction that makes a difference to the Justice Department.
A number of constitutional problems here. One is that the states don't have inherent authority over immigration. The states, according to the Supreme Court, have no sovereign right to regulate immigration. That was a problem in the Articles of Confederation. One of the reasons we went to a constitution is because of the disparate state immigration and citizenship policies under the Articles. So we have a uniform rule of naturalization and a federal responsibility for immigration. And the law in the Supreme Court has developed along the same lines, recognizing that this is an exclusive federal responsibility. And so preemption is one of the ideas here, but even without preemption, even without a federal statute that the state law is somehow inconsistent with, the states can't do this. I believe this because in 1876, the first important federal constitutional decisions about immigration said that New York and California could not regulate the ports, the disembarkation of passengers at the ports, even though at the time there was no federal immigration law. So it can't have been a preemption problem. There was no federal statute for these to be inconsistent with. But the Supreme Court nevertheless said unanimously this is a federal responsibility. If there is going to be regulation in this area, it has to be done at the federal level. That was
I think my comments will, in answering your question, Neil, will really just take off from where Jack's left off. To the question, the specific question, that is, what does Whiting teach us, and what does it have to say, or does it alter the way in which we might understand other types of laws like SB 1070? My short answer is no. We can all go home now. No, but it's a question worth asking only because at its highest level of abstraction, the Whiting case is about a state victory or state law victory as against, a claim of preemption, right? That is that there's a IRCA regulated employer sanctions, you have a state entering the employer sanctions market and surviving against a claim of preemption. And so, as restrictionists did claim in the wake of Whiting, so you had statements by, for example, Secretary of State Kobach, plus organizations like FAIR and Numbers USA making the claim that, well, this is clearly opening the floodgates. Whiting means that SB 1070 and laws like that are surely to be held constitutional by the Supreme Court. The Supreme Court is recognizing a new era of state involvement in immigration. The issue brief that I wrote for ACS argues that really Whiting tells us very little because the legal analyses are really non-transferable, partly because of some of the comments that Jack made. When you think about what's happening in Whiting in the business licensing area, you have in the Immigration Reform and Control Act in 1986 a specific provision which arguably has a written exemption for laws like Arizona. I think that's a contestable argument in the first place. That's why you have a divided Supreme Court in Whiting. But at least there's textual basis. You don't really have to get to larger constitutional questions, significant interpretive questions. One can simply look at IRCA, which says states shouldn't be doing sort of employer sanctions except in the way of licensing, and arguably LAWA, the Legal Arizona Workers Act, is a licensing type of law. But the Supreme Court, I think, is very clear in Whiting that its analysis is limited to the comparison of the specific Arizona E-Verify law to that specific provision of IRCA, and really does not go beyond that in any way. And in fact, though, it takes great pains to suggest that its opinion is not going beyond the specific comparison of state law to the federal employer sanctions law. When you think about unilateral entries of states into the enforcement arena, which is what you have in SB 1070, non-supervised unilateral assertions of state authority to enter into the enforcement area, you have very different bases upon which the state has to defend its policy. There's no exemptions clause in the INA that would allow that form of participation. So when you think about broadly how states have defended laws like SB 1070 or the Alabama law, in the way I see it, it sort of breaks down into three broad arguments. One is, as Jack mentioned, sort of a mirror theory argument. That is, we're doing exactly what the federal government wanted us to. Our goals in deportation are exactly what the federal government would have done, and therefore, we're doing it. This is the same thing. Second argument is that well, the INA allows for state involvement in enforcement in some ways, and this is sort of permission for a larger set of state participation in enforcement. And then the third argument is an inherent authority argument. That is, it really doesn't matter whether we're trying to mirror federal goals or whether the INA gives us some statutory permission to enter into enforcement. We as states simply have, by virtue of federalism, our sovereign powers, the ability to enter into the enforcement sphere.
Thing Neil said earlier, which is I was invited to be on this panel because ACS wanted one person who was not an expert in immigration law, and I certainly qualify on that score. So, I mean, the only thought I've ever had substantively about immigration law, I mean, call me crazy, but I think Congress should figure out what immigration policy we really want to have and should enact it, and then the executive should enforce it. The current system under which we have one official policy on the books, but we don't really enforce it, has always struck me as somewhat absurd. But to answer your question, it is interesting if you look at the trends in federalism jurisprudence over the last 20 or 30 years. There's clearly an increasing receptivity to arguments about state authority, which leaves me feeling somewhat about cases like the current SB 1070 case, somewhat the way I feel about the healthcare cases that are also pending before the Supreme Court, which is if you just look at the precedents, the federal government has a very strong case. You know, there's a case, Jack mentioned some of the cases, there's also a case from the 1940s called Hines, in which the Supreme Court took a very dim view of state authority to regulate immigration, saying that that was given by the Constitution to the federal government, and it was implicit that that preempted state authority. I think the trend in the cases that you see, it has not yet reached the point where you could say there's a majority for this position, but certainly an increasing number of justices are taking the position that the Supreme Court shouldn't be so quick to find implicit limits on state authority. It might be one thing if Congress passed an explicit limit, and as Jack pointed out, you could think Congress has indeed done just that in the immigration area. But I think at least some justices are more hesitant to find implicit limits on state authority. You see this, for example, in jurisprudence about the Dormant Commerce Clause. Justice Scalia, to a limited extent, and Justice Thomas, to a much greater extent, have said, you know, what do we need the Dormant Commerce Clause for? If Congress is unhappy with state regulation of interstate commerce, it could always pass a statute that would implement what we currently understand to be the Dormant Commerce Clause, but it's not something that the courts should impose. And another area in which you saw this very powerfully was in a sort of a unique case, the U.S. term limits case. This is from the mid-90s. It was about whether states have the authority to place a term limit on their congressional representatives. And Justice Thomas, speaking for four justices, said it's all about the fundamental constitutional principle that under our Constitution, the federal government is limited, the states are general, the federal government can do only that which is permitted by the Constitution, the states can do everything except what is forbidden by the Constitution. And that sort of Gestalt principle is what, for him, resolved that case.
Job growth. Why we as a state have yet to move forward in the manner that we should be able to, given the robustness of not only our core economy, but the diversity that we have. We should be doing better. The pressure from South Georgia, despite the fact that agriculture is our #1 industry by a factor, that pressure was not sufficient to overcome the political pressure, the need to blame somebody. And so despite not only our predictions, but their agreement with our predictions, it was much easier to say all of our problems will be solved if we get rid of colored people who speak a different language. And that's what we did. The problem was we lost a number of people, but we didn't solve any of our problems. And in fact, we created new problems. The most modest estimate says $75 million. I've yet to meet a farmer who believes that that's actually true. We think the number is closer to $1 billion. And that's not counting all of the small shops who aren't being interviewed, all of the people who sell tractors who aren't being interviewed. The overarching issue is that Georgia picked politics over economy. We picked politics over people, and we're going to pay the price for the next decade. But the reality is it's not going to get any better until we reverse course. And you know, we voted for a supplemental budget, and I'll wrap up. Last week, actually I guess it was Monday. I can't remember. My days run together. Yes.
When you're in the legislature, they all fly.
We voted for a budget, and they were touting the fact that in this budget they added $75,000 to help people apply for H-2A visas. The problem isn't do we have someone to help apply for it, it's does the program work? The answer is no. And if we spend as much energy lobbying our congressional delegation to take action on immigration, Georgia would not only have, I think, a growing economy, we would be a state that is an attractive place for people to come to, as opposed to a state that people are turning away from and heading in the other direction, namely Florida or Tennessee.
Thank you. All right, that's a great launching off point. So Chuck, you're a national advocate. You're well known among the folks that I live and breathe with in Washington, D.C., a trusted voice in terms of a commentator on national politics and policy and the direction that it's going. But you also have clients here, and you work closely with Stacey. You tried your best to stop this bill. You have to give people advice every day on now what the heck do they do. how does what happened in your state align or not align with what you see happening in Washington and across the country?
I really appreciate the opportunity to comment on that. You know, Leader Abrams, she did a fantastic job last session. I want to give her big kudos for trying to stop this bill. But you can't stop a bill that nobody's read, and that you had voted for anyway. And there were literally dozens of state legislators, senators and representatives who did not read that bill and did not care what it said. They were just voting, as you said, based upon politics. But on the ground, it's a different story. As word spread within the communities here in Georgia, this bill was going to pass and it was going to have all these effects. Of course, they're blown out of proportion initially by much of the Latino press, but at the same time, they have dire consequences for people's lives. One of the best things we were able to do, thanks to the ACLU, the Southern Poverty Law Center, is get an injunction in place. Georgia legislature, I love talking to people about this. How much money did the Georgia legislature allocate to the enforcement of HB 87? Everybody, you go and cry, oh, $1 million, $10 million. Zero. Not a dime was allocated for enforcement of a bill that required massive amounts of training, which would cost money, large prisons to be built to hold all people using fake documents. Yet none of this happened. No money was ever allocated for it, which I think sent the real message about what they really intended the bill to do, which is to scare people into leaving. Once that injunction was in place, it stopped the 4 key provisions of that law from taking effect. People stopped leaving, and that was the story on the ground in Georgia. Yes, some people left initially, but all I can say is thank God for Alabama. Thank God for. I'm sorry to my friends in Alabama, but thank God for Alabama. You make us look reasonable. In some way. People stopped leaving, and they haven't left since that injunction went into place in June. People have not left, unless they were escorted out of the state by our friends at ICE. People have not left. There was big talk in the state legislature last year that the schools in Whitfield County, Dalton, Georgia, for those who don't know it, large carpet manufacturing area in Georgia, lots of immigrants, almost 50% Latino. Gwinnett County, huge immigrant populations, many folks up there undocumented. There were fears the schools would empty out. People would take their kids and be gone. And what happened? More kids came. Not only didn't they empty out, the schools got bigger. So yes, some people left, but many people stayed because that injunction went in place at just the right time. If we hadn't got that injunction in place, or hadn't stopped all 4 provisions, it wouldn't have happened. But still on the ground, HB 87 is not the problem right now in Georgia for people on the ground. The problem on the ground right now in Georgia is secure communities. An Obama administration pushed an initiative to basically require anybody who's brought into the custody of any police officer in Georgia to send their fingerprints to ICE and then have a 48-hour hold placed up on it. That is the law that's causing the real damage in the community. I get calls every single day. My husband got picked up. My wife got picked up. My son got picked up. What do I do now? And the reality is, for many of these people that don't meet the criteria for the very limited type of relief that is available to them, there is nothing you can do. And you couple that with the immigration judges that we have at the detention centers here in Georgia, and people not only are being deported, they're not getting bond. So they might have been here for 9, 10, 12, 15 years, but because they have no relief, they get no bond. So they are literally deported from the United States, from that detention center. So they never get to go back to their house and pack their clothes. They never get to sell their car. They never get to close out their bank account. They're literally just deported. And on the ground, it's having a very debilitating effect. This morning, I spoke up at a conference of the ESOL teachers, their annual conference here in Georgia. It's about 400 teachers there that focus particularly on the Latino community, kids who need a second language learning experience. And repeatedly, they came to me afterwards and said, Johnny in my class, both his parents have been deported. Johnny's a senior. He is the senior person in the house. 3 little brothers and sisters. He is raising those kids as a senior in high school because mom and dad both got deported. And the kids are afraid every day they're going to go home and dad's not going to be there or mom's not going to be there. This law had more of an impact, I think, on children and the psyche of the children to cause fear in their minds, many of whom are U.S. citizens, than just about anything else. And in that respect, Matt Ramsey and Golick and his buddies in the state legislature that wrote this bill, or that took the bill from the folks who wrote the bill, accomplished their purpose. They created fear in the hearts of the immigrant communities, but they didn't scare them out of Georgia. And that I think, is the bigger story, because it's a story of heroism on the part of folks who say, look, I came here for a better life, and you can't scare me away that easy. And I'm not going to be scared away that easy. I want to be part of this country. fact, we should be welcoming these people at this point, and yet we're not. So on the ground, hardship, heartache, heartbreak for people. Struggle continues, but folks are adapting. They're adapting by not going to the schools for parent night with their kids because they're afraid to drive, or using public transit more than they ever have. I'm sure Marta's doing great business these days because of this. But at the same time, you've got an impact on the community, which is the other on the ground. I don't represent just immigrants. I represent their employers. I've been down to Moultrie several times in the last couple of months. Moultrie in South Georgia is kind of I call the agricultural center of South Georgia. And they got particularly hard hit by the lack of agricultural workers who came through. Our bill passed right at the time in which migrant workers would begin coming from Florida to Georgia to pick our spring crops, April, May, right then when they started coming. They didn't come because of this bill. They literally skipped us. I had a friend in North Carolina called me and said, all your migrant workers are here. What are you here so early for? Can't go to Georgia. They must have taken 95 to Savannah, popped right into northern South Carolina. And even in December, you could go to the fields of tomatoes. What were tomato plants? Dead plants, which you normally see, and all the little red spots. All the tomatoes, really millions of tomatoes in these fields that went unpicked because we didn't have the migrant labor. Now, I've asked farmers about what happened in the fall crop. And in fact, people did come back through Georgia because the law got stopped. And so that fear kind of went down. We're going to know a lot more in April and May this year about the real impact, because the fall crop is much smaller than our spring crop. Or we're going to see the price of cotton go down, because cotton doesn't require migrant workers. So we're going to see farmers plant crops that don't require intensive labor. That's what they planted before. And that's going to have a severe economic impact. And by the way, I think the number is very close to $1 billion. The restaurant industry in Georgia has been very hard hit by this. Not only in workers in the restaurants, but restaurants owned by immigrants. Any of you have come from an immigrant background like I do, what did my grandparents do when they came to America? They had a restaurant. And it was an excellent German restaurant, but they had a restaurant. I mean, it's a very easy industry for immigrants to get into. Restaurants have shut down because of this. They've moved away. You all live in communities where that great Mexican restaurant used to be, it's not there anymore. Or the nice Thai restaurant that used to be, it's not there anymore. Etc. Debilitating impact on businesses in the communities because people are afraid to go out. They're not leaving, but they're afraid to go out. So in many respects, they've accomplished their purpose part of the way, but I don't think they're ever going to accomplish it all the way.
I kind of serve in dual capacity. I'm a lobbyist, and I also see what's happening on the ground. And, you know, I will say we do have a strong immigration coalition that we had people attending every single hearing on that immigration law. We had people at midnight sessions when we were sitting there at midnight at the State House. And we even had one hearing where we had almost 30 people testify against the bill and no one's for it, and they still passed it on a subcommittee. So we knew we were never going to win that as long as the certain powers that control the State House were there. So we had to come up with kind of a strategy for what to do. And I had ally legislators saying to me, do you want us to put in amendments? And I said, no, let it be as bad as it wants to be, because the Southern Poverty Law Center has already told us, we'll partner with you and we'll sue. So we knew that was coming. They reached out to us as soon as that bill was introduced, said, you don't know us, but here we are. We're going to come over and sue. So our strategy, we had to change our strategy and just still fight at the State House and figure out what we're going to do with the people. And what we're seeing with the people now is, even though the law has been enjoined by our federal judge in Charleston, people are very confused. And it's all about 287G and secure communities. And they don't understand that that's not part of the law, that that's completely separate. People are also impacted by, I routinely talk about, and even though I don't think they're always the best course, but powers of attorney and planning for children, getting everyone's documents in order from the consulate, and worst case scenario happens. People do not want to listen to me because they are terrified about the thought of leaving their children here. We're seeing that as a major problem right now. We're seeing the Padres taking advantage of people and saying, we can do your immigration paperwork, we can get this, you know, those new prosecutorial discretion memos the Obama administration issued, we can get your legal status under those. That is a major problem in our communities right now. People are being taken advantage of. We do have a lot of what you were indicating about children terrified. We have more and more
sort of trace kind of our response in partnership with a number of community organizations and with national civil rights organizations, and how we've tried to address what we saw happening in Alabama when major parts of the law went into effect. And then sort of bring us up to the present. One of the first things we did was launch a 1-800 hotline that people could call, which was very widely publicized on Spanish language radio throughout Alabama. And to date, we have received approximately 5,500 calls on that line of people. It was just, at that point, I think we were all in shock, and I think we're all feeling what Tammy's feeling to some extent, honestly. But we all kind of sprang into action here to try to respond to just the confusion and fear that people had in those first days. And we still answer the hotline in partnership with other civil rights organizations, the ACLU and NILC, among others, who've helped us answer the calls that we're getting, where people are just wanting to know, what is this law doing to me? What is it doing to my life and my kids? And answering questions, I think, to a great extent about what do I do if I have children and I get deported here, and powers of attorney, questions about one's rights under leases and housing arrangements, questions about one's rights when interacting with the police. Those were very commonly heard things, and I think some of what Tammy was talking about we're seeing in Alabama as well, with people taking advantage, unfortunately, a lot of questions about, should I be transferring the title of my home or my car to a U.S. citizen or somebody with legal permanent residence? Well, if you do that, you're signing away ownership of your most valuable assets, but you can't register your car anymore in the state of Alabama if you're undocumented. That was a major issue for people who were calling into the hotline. And I think we still are seeing tremendous fear. I do think people have left Alabama in droves, and maybe some of the national experts here might have some up-to-date statistics on that. Just anecdotally, I can tell you that I was doing outreach in support of some poultry worker rights advocacy that we were doing in Alabama right after the bill passed, and a number of trailer parks had cleared out. Many people weren't waiting around for the court decision, and that just got worse once the court decision came down, upholding many parts of the law. Just to walk in trailer parks in southern Alabama and northern Alabama that had formerly been populated with families, and to go door to door and see that it's just abandoned, it's vacant, and the people that were there were very afraid, and were like, what's this white lady doing knocking on my door? Is she with immigration? And just what the sort of conversations that you had to have with people just to get them to talk to you, and you weren't even talking to them about the immigration law, you wanted to talk to them about how is work going in the poultry plant that you used to work at or used to work at. So I think we anecdotally, I think those of us who've done outreach on the ground in Alabama have seen a tremendous degree of fear in the Latino communities there.
And thanks again to ACS for organizing this important symposium, and to all of you for joining us. I think, as Judge Clemens said, it is not a surprise that we lost in Alabama. We at the National Immigration Law Center have been fighting the anti-immigrant battles since Prop 187 in California in 1994, along with our broader civil rights coalitions, and have been providing support to state advocates year after year, especially around 2005, which is when we started seeing the proliferation. And there has been a very intentional design by immigration restrictionists, by conservatives who have a very different vision for our country. And it is very much grounded in the shifting demographics. It's not a surprise that when you see the map that Cecilia shared this morning, the Southeast has a cluster of states that have actually enacted these laws. And in Alabama, I think we believe that it is very much rooted, the decision by Judge Blackburn, which is the one federal court we've lost in these recent anti-immigrant battles, is very much rooted in the structural racism, and as Stacey was saying, the powers that be, the political forces in place. And so when we lost at the district court level, we appealed to the 11th Circuit, and we're fortunate to at least get some additional provisions blocked. But I do think that regardless of where the Supreme Court goes, so we have the Arizona versus United States decision, which we will get a decision on later in this session. We're currently slated for a hearing on April 25th, and the 11th Circuit is hearing both Georgia and Alabama on March 1st. But The Arizona case is strictly about, it's the Department of Justice lawsuit, it's strictly about the preemption issue. It will not address the broader constitutional challenges we've brought, Fifth Amendment, First Amendment, Fourth Amendment, et cetera, in the broader civil rights claims. But most importantly, I think just to bring it back to what this is really about, it's not going to do anything. The Supreme Court decision, the day after it issues its decision, it is not going to do anything to undo the inhumanity that has been forced upon our communities by these laws. It's not going to do anything to address the concerns of Mayor Paul Bridges, the mayor, Republican mayor of Uvalde, Georgia, who's one of our plaintiffs in our Georgia lawsuit, to address the concerns he has about the economics, of how it's impacting his local economics and the immigrants and U.S. citizens who live in the community. It's not going to do anything at all to address the fact that this isn't affecting just undocumented immigrants, that it's affecting all Alabamians, all Georgians, all South Carolina, people from South Carolina, because one of the things we have to think about is immigrant families live in mixed status families. It's 85% of families include a U.S. citizen, a lawful permanent resident, maybe a refugee, maybe somebody who's undocumented. And we are families that have deep, deep roots in the community and are contributing in so many different ways. So when you have a law like Alabama that, as Tony West said, affects every aspect of society, right? We, many people who are here, who are officers of the court, as a lawyer or as a judge, an interpreter, who in Alabama, all of these officers of the court have the duty now to report, to verify the immigration status of people who appear before them and to report them to immigration. We are turning the clock back to what Judge Clemens talked about, a day in this country where the inhumanity of the person was based on the color of their skin. And now it is simply based on the color of their skin, their national origin, the language they speak or don't speak, or whether they speak it with an accent. And so what's at stake is just tremendous, and the pain will be there. And so until we have federal reform that really truly addresses a path to citizenship and addresses the fact that we have an immigration system that is completely outdated, that doesn't, in fact, provide for any path to citizenship and provide ultimately first-class citizenship for everybody who's in this country, we will continue fighting this fight. And it's not just a legal fight. It is very much about building political power on the ground.
That has been kind of a shining light out of all of these anti-immigrant laws is the coalition building, right? I think in particular to see the immigrant community and African-American community really come together and understand each other, right? So as immigrants and as immigrant rights advocates, to really learn about the African-American history in this country and civil rights history and what the similarities are and what there are differences about how our communities have been treated, understanding that, of course, slavery was very different from what our communities are going through right now. But again, looking, as Judge Clemens shared today, what are the similarities with the Black Code? How is it that this is bad for the community as a whole? So I think the broader coalitions, the faith community, has been critical to really put this in a moral light. I think in addition to the business community, I have to say, and this goes a little bit to the communication strategy, one of the things, the challenges that I think we've seen with Alabama is that we assumed that once Alabama went into effect and we saw the rest of the law, that the country as a whole, and that the progressive community in particular as a whole, that it would shock the conscience of the nation. And it hasn't done that yet, frankly. People still don't understand all of the different components. And we as lawyers, I remember, answering the hotline in Alabama and just, after every call on the hotline, we at the National Immigration Law Center, we would get together and literally, as lawyers, we're like, really? That also is impacted by this law? It was just this intellectual puzzle that was created by the law, but then again, the inhumanity of it all in terms of how it was affecting people. And we haven't been able, I think the communications work we've all been trying to do has been incredible. The fact that This American Life covered the mobile home, right, that was a lot of very intentional strategic work, but the level of pain and suffering that's happening in the country at all levels, right, whether it's from the economic business perspective or from the individuals being affected by this in the community, hasn't shocked the conscience of the nation yet. And that's very, very worrisome. And so I think there's a lot more work to be done to be able to say to the country, look, we should all be opposed to this, regardless of where you
stand on the political spectrum, this is not what this country is about.
I mean, it's Little Asia, whether it's Korean, whether it's Vietnamese, whether it's Chinese. If you go over to Marietta, one of the largest expatriate populations of Kenyans in the world is in Cobb County. I don't know why they're in Cobb County, but they're in Cobb County. Immigrants in Georgia, here's an interesting fact. We get a new congressional seat this year. You know why? Immigrants. 800,000 immigrants. We got a new congressional seat. And who's going to fill that congressional seat? Somebody who signed it in 1987. That's the irony of the state.
Yeah.
So it impacts every ethnic group. It's just that Latinos are the biggest number of them.
Issue that is significant for other ethnic groups. I would guess not.
It actually is. I mean, when you've got African immigrants, African refugees, for example, same thing for South Asians. There's been a tradition, especially after 9/11, we saw racial profiling particularly impacting the South Asian community throughout the country. But one thing though, so one is these laws affect all immigrants, regardless of where you come from, what the color of your skin is, but it is important to understand that it is very much an anti-Mexican sentiment that has really spawned a lot of it, and that's very true. Again, you're looking at the border states primarily that are enacting these laws. So at the root, it is very much about an anti-Mexican, anti-Latino, but the impact is, and again, not just on the immigrants, but their family members and community members as a whole. So I think it is important that although we may talk about it, about the impact being greatest on the Latino community, the other piece is for the undocumented community. Again, the thought is primarily Latino, but actually one of the largest growing number of Latinos, of undocumented immigrants in the country is people from India, people who come on a visa and then overstay the visa and are equally undocumented. So this is among the myths that exist out there that it's a
advocate, bring attention, first of all, to the massive crisis of incarceration in this country, which encompasses far more than immigrants, but immigrants has been particularly, it's been particularly notable for the entry of the private correctional, corporation to sort of making money off civil detention. I think that it's really important to shine a light on the conditions in those facilities. These have raised some very complicated issues in these rural communities because, as you know, many of these detention centers, the privately run detention centers, are located in rural southern communities where there are very few employment options. I think it's important to highlight how this is not a sustainable way to grow and build jobs, and that it's ultimately destructive, and to think about other ways that we can develop the economy in rural places, but also to shine a light on the conditions that are happening there, people dying from inadequate medical care, people being locked away for months on end without getting proper hearings, and those sorts of things. So I think that litigation is an important piece of that, as well as other advocacy. I don't know, maybe some other folks have some ideas on that.
Untitled Chapter, the ACLU here in Georgia, has done remarkable work in pointing out the problems caused at our CCA facilities, both in South Georgia and in North Georgia, as well as the county-run facility down in Osceola. But what we've seen a lot in the Latino press, there's a big article, in fact, in the biggest Hispanic newspaper here in Atlanta this last week, on a boycott of Wells Fargo, who is a heavy investor in CCA. And I think you're going to, if you want to make a point, businesses understand money. That's the bottom line reality. So if you stand for saying these private prisons shouldn't exist, and they shouldn't be profiting at a rate of almost $40 a day profit of every immigrant they detain, $40 a day of profit, then we shouldn't participate with businesses that own their stock. And that's been that boycott that's going on. It's just starting of Wells Fargo. Now today is a terrific work here in Georgia.
Yeah, and I think that's a really important question, because part of it is really exposing who is benefiting from this, and what is the economic incentive behind these laws. And there are a lot of organizing efforts really, I think, finally taken root in the country to make the connection. And I think this is something that the broader, I think in this country, Occupy Wall Street has done a good job of starting this national conversation about the role of corporations and corporate greed. And in the immigration fight, that's part of it. It's a central component to that. And so I think exposing that, informing ourselves about what those economics are, and then appropriations, right? I think as Senator Abrams talked about, right, there weren't any appropriations for HB 87. Why is that, right? What were really the priorities besides scaring people away? And self-deportation, as Mitt Romney likes to push for, which is really about the attrition through enforcement. And that's very much, again, this intentional effort by the right, by the restrictionists, to make people go away, while at the same time co-authoring these laws, these bills, to make sure that these certain corporations get a profit from it. So you've got this dichotomy of corporate greed and inhumanity happening at the same time, and exposing that and looking at the appropriations process both at the state level, state legislative level, city level, and federal level as well.
AnibalShow.com